Hello, everyone. Welcome to Court with Krissy. Judge Williams even says it. He deals with meth cases all the time. So I'm quite confident that he can do his job with his eyes closed. No big deal that he nods off a couple of times. Between the attorney's slow speech and scrolling through the iPad and phone, my eyes would probably be tired too. I hope you like it. Court with Krissy is now in session.
Okay, Commonwealth versus Austin New, 24 CR 0032 and 24 CR 0033. Are you Austin New?
Yes, sir.
Hey, we're here for a motion to determine competency to stand trial. You have your witness.
We have her lined up, Your Honor. Is that right in?
She's on there. She's on
She's
there.
already here.
Okay.
Okay.
Would you raise your right hand? We have Megan Green or Dr. Green or
Yes, sir.
I'm sorry, I just want to make sure I gave you proper credentials. That you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
You state your name, with whom you're employed, and what your credential is.
Dr. Megan L. Green, ID, and I am in private practice, but I am a contract evaluator for KCPC.
Okay. Mr. Hunley, you want to proceed?
Yes, Dr. Green, you are here today to give an assessment on Austin New. Is that correct?
Yes, sir.
Before we get into that, could you give Judge Williams your basic credentials and educational background that brings you here giving these opinions?
Yes, sir. I have a doctorate in clinical psychology and postgraduate training in forensic psychology, and I've been in private practice in forensic psychology in Kentucky since 2010, and in West Virginia, also in forensic psychology since 2017.
How long have you been in this field?
Since 2007, in some capacity, but in private practice since 2010 in Kentucky, and then for the past
Were you
8
doing?
years now in Virginia.
Go ahead. Did you do the evaluations on Mr. Pugh as part of your private practice or through contract with KCPC?
Both, sir. So I'm in private practice. I'm not directly employed by them. I'm a contract evaluator. So the referral comes through KCPC, but it's through private practice as a contract.
All right. Yeah. Did you do an evaluation on Mr. Pugh on both his capacity to understand and accept criminality laws in Kentucky and on his ability to participate rationally in his own defense?
Yes, sir.
Did you make two separate evaluation? Did you evaluate him on two separate occasions, or did you just evaluate him on one and do both at the same time?
So it was only one evaluation in terms of the meeting, but because there were two types of referral questions asked in terms of competency and then also criminal responsibility, those are two separate reports. One for the ease of the court, but also sometimes the criminal responsibility portion is submitted separately. To protect the defendant. And so in terms of the appointment, it was only one assessment meeting. However, it was two assessment reports.
Now, when did this assessment take place and where was it done?
He was evaluated at the Adair County Jail in person on June 26th, 2025.
And can you tell us the physical setting that you're there and the length of time that you spent with Mr. Pugh?
Yes, sir. So, in terms of the meeting room there is a private meeting room where you can meet with inmates and evaluate them and speak with them. And so I was able to sit at a table at the same table with Mr. New at that time. And in terms of the evaluation, the face-to-face time for the evaluation was 5 hours.
All right, could you give the judge more or less of an outline of the process that you went through uh, with Mr. Pugh in order to come up with the evaluation and assessment that you have made?
Of course. So, in terms of the clinical interview, that is where a defendant is asked to give their personal history. So, ask questions about the defendant's family of origin and their social history, also their educational history, their employment history, their mental health treatment history, their substance abuse history, their medical history. Also, ask questions, of course, about the person's current mental status, any symptoms that they have in terms of mood or other types of mental health concerns. And that's the clinical interview. Also, he was administered an IQ test, which was the Kaufman Brief Intelligence Test, second edition revised. Also, an inventory of legal knowledge, which is a competency specific test that specifically assesses for feigned incompetence. He was also administered the personality assessment inventory. That is a self-report measure of socio-emotional functioning, and it addresses chronic and acute mental health concerns as well as personality pathology. And in terms of competency-specific tests, another competency-specific test is the evaluation of competency to stand trial revised, or the extra, and also in this case a criminal responsibility interview because that question was asked as well.
In the examinations that you made, did you inquire of him about his family and social history?
Yes, sir.
Did your brother inquire and discuss with him his employment history,
Yes, sir.
his psychiatric history,
Yes, sir.
his medical history,
Yes, sir.
his substance abuse history, if any?
Yes, sir.
Any psychological tests that were run or had been run on him?
Yes, sir. There was the Kaufman Brief Intelligence Test, second edition revised, the inventory of legal knowledge, the personality assessment inventory, and the evaluation. Oh, wait.
Doctor, there's another camera, RCDC. Will you turn that camera off there, please? Just turn it off. Just turn the camera off. We'll get back to that in a minute, okay? Thank you. Go ahead, Dr. Gray.
So in terms of tests, there was a Kaufman Brief Intelligence Test, second edition revised, the inventory of legal knowledge, the personality assessment inventory, and the evaluation of competency to stand trial revised.
Did you, in determining his capacity, come up with any diagnostic impressions?
Yes, sir. So in terms of diagnoses, they included post-traumatic stress disorder, alcohol use disorder and sustained remission, cannabis use disorder and sustained remission, stimulant use disorder, amphetamine type substance and sustained remission, opioid use disorder and sustained remission, and sedative, hypnotic, and anxiolytic use disorder and sustained remission.
What were your findings on those various tests?
So in terms of IQ testing, his IQ was in the normal range. His IQ composite score of 96 falls in the average range. His verbal standard scores and his nonverbal standard scores were very similar to each other. They weren't statistically significantly different, and they also both fell in the average range. On the inventory of legal knowledge, he responded correctly to 55 items of 61. That indicated a good fund of legal knowledge, and it also was not suggestive of feigned incompetence. On the personality assessment inventory, there were some indications that he portrayed himself in an especially negative manner, and due to that response style, the results were assessed to be invalid on that particular test. On the competency specific test, he was able to demonstrate a good factual knowledge of legal constructs, and he also was able to demonstrate the capacity to participate rationally in his own defense and collaborate with counsel.
Now, did you have provided for you as background for this interview and an examination the accounts of his alleged crimes?
In terms of discovery, I did have access to the discovery information that were associated with the alleged offenses. And then, of course, along with that, the defendant's own account of the alleged offenses is gathered from that person as well.
In the examination, did you have any discussion with him concerning the accusations made against him?
Well, let's stop.
Without telling me anything.
Let's stop that. Okay, this is about competency only today. Correct? Yes.
And criminal ability to assist his attorney.
We'll proceed cautiously.
Without going into detail at all, did you have some discussion with him regarding the charges?
Yes, sir.
And were the answers that he provided you part of the reason for the assessment that you subsequently made?
So in terms of the assessments, there are, of course, the two questions that are asked here. One is about competency and one is criminal responsibility. So they certainly came to bear on the criminal responsibility portion of the evaluation.
All right, now, we do have two separate issues here. Could you tell the court what you went into with Mr. Pugh on whether he could assist his counsel in his defense?
Yes, sir. So in terms of inquiries along those lines, you ask the defendant about the charges, the nature of the charges, and you assess whether they have a minimal threshold of understanding of the charges. You ask about how that person is able to relate to his or her attorney. So you ask questions like, do you think that your attorney is doing a good job? Are there any concerns that you have about your case? And sometimes people who have conditions that render them incompetent, they will have answers to that are concerning and would cause you concern that they are not competent to proceed. So you ask about their understanding of the status of the case. You ask about potential outcomes. And then you assess whether they are able to behave in a self-serving way. So in other words, are they able to ask their attorneys relevant questions? Are they able to ask their attorney for advice when it's necessary or reasonable? And those are the types of questions that you would ask when you assess somebody's ability to collaborate rationally.
Did he understand the role of the prosecutor in the system?
Yes, sir.
Did he understand the role of the defense attorney in the system?
Yes, sir.
Did he understand the role of the judge and jury in the system?
Yes, sir.
All right, Doctor, based on your examination of Mr. Pugh, do you have and were you able to form an opinion regarding his competency to stand trial?
Yes, sir. The eventual opinion that was rendered after all of that information was gathered is that he was competent to proceed, and specifically that he was able to appreciate the nature and consequences of the proceeding against him, and that he also was capable of participating rationally in his own defense.
Were you also able to formulate an opinion on his capacity?
His
Criminal responsibility.
Oh, yes, sir.
And what is that opinion?
Let me bring up that report. I did not bring that one up today because it was competency today, but let me bring that up. So in terms of criminal responsibility, the opinion in that report is that he had the substantial capacity to appreciate the criminality of his conduct and to conform his conduct to the requirements of the law.
Have you generated reports on both of these elements of your findings?
Yes, sir.
They have been forwarded to the court here in Cumberland County.
That's my understanding.
All right, now, counsel for the defense.
Doctor, excuse me. Dr. Green, you did, it was one interview for both of these purposes, is that correct?
Well, it was one assessment appointment. So if you're asked for competency only, obviously there are things that you don't go into as opposed to ask when you're asked about criminal responsibility as well. So it's the same appointment, it's the same types of assessments, but it's an expanded interview that obviously covers more information because there are the two questions asked instead of one.
And you spent 5 hours total to address both issues, is that correct?
Yes, sir.
And do you recall how much time of that 5 hours was dedicated to each question? That being
No,
competent responsibility?
No, and the reason that it's hard to tease that out is because you only do one clinical interview, you only do one IQ test, you only do one clinical interview, so you would not repeat those because there's just not a reason to for each question. You do add a criminal responsibility interview, you do add competency specific tests, but in terms of the relative contributions of those, I don't know exactly what those would be.
And I guess just to clarify this, the clinical interview was conducted while Mr. New was in the detention center, right?
Yes, sir.
This was done though by Zoom, is that right?
No, it was in person.
Oh, you traveled to the jail?
I did.
I guess in the competency report on page 2, with a statement of non-confidentiality, the transmission between the detention center where the defendant was housed and my private office was adequate for evaluation purposes. Is that just?
No, there was an expert retained by the defense, Dr. Lauren Kaplan, and she was present by Zoom. I was present in person at Adair County Jail, and she was present by Zoom. So I met with him.
Private office may have been just kind of her private office. Maybe.
That's right, and I could have phrased that better.
No, fair enough. KCPC did make a request to be able to conduct the interview by telehealth or teleconference, did it not?
I think that is generally the practice because that creates ease with scheduling. However, if there is a situation where there is an interpreter or another expert that needs to be present, I try to cut down on that as much as I can, and I try to go in person whenever possible.
Okay, very good. And then you, in terms of the materials that you had reviewed in advance of the, of your clinical interview, that included the order to conduct the evaluation, is that right?
Yes, sir.
A basic court net printout, and then
Yes.
what you referred to just broadly as discovery. Do you recall what specific materials you reviewed prior to your assessment?
So in terms of discovery, what I do is I make myself familiar with the charges. And then I read through discovery once, and then I go through and read through it again after I talk to the person. So that way I make sure that I understand on both ends. And this is in the criminal responsibility report, in terms of the specific discovery, there were a few things. One of those was a crime supplement. There were text messages. There were actually a very large number of text messages that were included in discovery, and I was able to review those.
I don't want to go down this route here. Okay, what, do you think this is beneficial to your client? To expose some of these things to the prosecution? I mean, you can proceed if you want to.
Well, I'm just asking her about the discovery. I presume the Commonwealth tendered to her. I was just asking what she had reviewed in anticipation or in preparation.
Go ahead.
Was the discovery that you had mentioned was tendered to you by the Commonwealth? Is that right?
So when I see discovery, I don't actually know who sent it. And so when we receive records at KCPC, they are uploaded to the defendant's file, but there is not necessarily, sometimes there is, if you can tell who mailed it or so forth. But in terms of discovery, there's not really a way for me to know who sent it because I'm not the one in direct receipt of that. I just open the file and see what's in it. Sometimes there are folders that contain records that are specifically labeled from counsel for the defendant, and so you would know that way. So in terms of these documents, I don't actually know who sent them. I can find out, but I'm not the one who receives those directly.
Okay. Did you, and you did not review, I suppose, just by its exclusion, or you didn't review any prior treatment records of Mr. New of any kind of medical or psychiatric nature, did you?
No, sir.
It was revealed during your interview with him that he had served in the military, correct?
Yes, sir.
And you were aware that he had been treated at the Veterans Administration in the past?
Yes, sir.
That you were aware that he had a prior diagnosis of post-traumatic stress disorder?
Yes, sir.
That he had been deployed in a combat role in the early 2000s?
Yes, sir.
And he had described to you, some things about that combat, some various incidents where, kind of with some gruesome sort of things, some IED blasts, some kind of fatalities, and witnessed things that he had seen when he was over there. Is that right?
Yes, sir.
And it was your understanding that his PTSD diagnosis had stemmed, from that it was service connected. Is that right?
Yes, sir.
And were you aware that he is 100% disabled with a service-connected disability through the VA?
He indicated that he was service connected. I don't know that he necessarily indicated the percentage of that. But in terms of the service connection, he did mention that when he was discussing his past interactions.
Was there any effort made to review any records from the VA?
So in terms of record review, if it does not make a difference for competency, I don't belabor the point for records. When it comes into play very clearly and very specifically, is when somebody's incompetent and you need to formulate an opinion about restoration, because you need to know how they've responded to various medications and treatment purposes or treatment approaches in the past. So in terms of records, generally speaking, it takes much longer to get those records than we are allowed to sit on these reports. So you have to ask yourself, does it matter? And I mean no disrespect to anyone, particularly and especially not Mr. New. But if it does not come to bear on competency, then I would not delay the submission of the report by doing that. It was my understanding that those records were remote. They had been documented quite a while ago. So in terms of their contribution to his competency, they're probably non-contributory at this point. And you just have to ask yourself, does it matter if I do see them? And so while they're certainly relevant to him and his well-being in terms of competency, it's hard to imagine that they would have come to bear on his current competency status.
Would they have bared on his, on your conclusion regarding his criminal responsibility and his mental health status at the time of the alleged offense?
No, sir, because they are remote records. So unless there is some history of some kind of recurrent mental illness that came to bear on the person's alleged behavior, then it would. With that said, when there are additional evaluations, when there are additional records available, these findings and these conclusions can always be amended if those become available and there's new information that's evident.
Well, if you're talking about recurrent mental illnesses, those records, presumably would have documented the post-traumatic stress disorder that you're saying persists with him, even with your diagnostic impressions. Is that right?
That's right.
And so how is it that, if that is kind of a recurrent then kind of sort of condition, would that not have bared on an opinion with criminal responsibility in this case?
So in terms of post-traumatic stress disorder, there are very few occasions in which post-traumatic stress disorder would come to bear on criminal responsibility. So in terms of criminal responsibility, there is not much about post-traumatic stress disorder, if anything, that makes a person incapable of knowing what's illegal and what's not. There is some literature that there have been kind of automatic responses that have been part of assault cases where a person has been affected by post-traumatic stress disorder, and an argument has been made that the person is not capable of formulating intent. But that's not what Mr. New described. And so in terms of post-traumatic stress disorder, just the literature on it and the way that it presents and the way that it comes to bear on criminal responsibility, we would not expect a disorder like PTSD to render a person incapable of forming intent or incapable of knowing right from wrong.
There's also a component to this with respect to methamphetamine, isn't there?
Yes, sir.
He had reported to you that he had been a regular user of methamphetamine for what I think he just estimated as 7 years.
Let me check that. That sounds right, but let me check it. Yes. So what he specifically said is that he began using methamphetamine when he first got out of the Marine Corps, and that he used it regularly, or I'm sorry, he began using it regularly around 7 years ago, meaning 7 years prior to the day of the evaluation. And he indicated that he last used the drug the day that he was arrested.
Okay, and is there any known connection between chronic abuse of methamphetamine and kind of, either exacerbating or it's an interplay with other mental health issues, whether it be PTSD or other mental health conditions? There
are a lot of them. So in terms of the effects of methamphetamine, it is probably the drug most known to induce psychosis. And when I say psychosis, what I mean are things like psychotic delusions, auditory visual hallucinations. So it is probably more so than any other drug known to induce symptoms like that. Even in a person who did not previously experience those types of symptoms in other ways, in other contexts. In terms of its exacerbation of PTSD, there is a symptom cluster in PTSD known as the hyperarousal symptom. I'm sorry, the hyperarousal cluster. And that refers to hypervigilance, anxiety, hyperarousal, generally exaggerated startle response, irritability, sleep disturbance, um, and recklessness. And so, in terms of what we know about use of methamphetamine, it is known to exacerbate that particular cluster. When you exacerbate sleep disturbance, you make it more likely that the person is going to experience distressing dreams. And so sometimes you can even see an exacerbation of re-experiencing symptoms that are characteristic of PTSD as well.
I don't want to attend a symposium on this thing. I don't see that this is that relevant to my decision today. She's given an opinion. You're asking what the basis of the opinion is, but I think you've gone far enough for that.
Well, Your Honor, the reason I think it results in a bit of a symposium and in a long-winded response is I think that there
I
is
didn't call you long-winded, doctor.
I'll take the hit on that one. But
Yeah.
there is, there is a lot of connection between chronic methamphetamine abuse, which is documented in this case, and bearing on things like she's saying, like inducing psychosis and
But you're
delusions and
asked-
things
I
like this.
understand- I
And
understand
so,
that. I deal with it all. I deal with it
I know.
all the time. So what I'm asking you is, she's given an opinion here. How are you're
I'm asking-
examiner now? At some juncture, you have to put forth the question, and I'm ready for you to do that.
How did you take into consideration 7 years of regular methamphetamine use combined with what is a history of mental illness and how it may have bared on his mental condition relating to competency and or criminal responsibility?
So in terms of competency, like we said, it's kind of a present time construct. And so his competency specific skills were certainly intact. At the time of the evaluation, he was certainly not psychotic. There were no indications of any active psychotic symptoms or other mental illness symptoms that would reasonably impede his competency at this time. In terms of criminal responsibility, it's my understanding of the law that voluntary use of an intoxicant or a mind altering substance or a drug, more generally speaking, does not meet the definition under the law of a mental condition that would lessen criminal responsibility. And so, for that reason, if something is substance induced, then it would not come to bear on criminal responsibility as the way it's defined by the law.
So it didn't factor into your opinion because of a legal conclusion that voluntary intoxication doesn't meet what you understand criminal responsibility to mean?
Well, that's not all. So that's one issue, certainly, but that's not all. So in terms of other, and I don't know.
What about in a clinical sense?
Yeah, and I don't know how much I'm trying to tread carefully because this verges out of competency and into criminal responsibility. But in terms of the factors that played into criminal responsibility, there were a lot of indications in collateral records that there were not substantial contributions to mental health, to his mental status, insofar as he was not disorganized in his thinking. So, and what I mean by that is that there are these extensive communications that do not reveal disorganized thinking. They don't reveal delusional thinking. There is certainly evidence of goal-directed activity. Some of those communications would be described as manipulative. Some of the communications certainly reflect a conventional criminal motive rather than a psychotic one. Some of the communications reflect higher level thinking and planning. So in terms of his conduct at the time of the alleged offense, there are just no indications in those collateral records that psychosis was something that contributed significantly to those offenses.
My last couple of questions are relating to Mr. New's effort and I guess the sincerity thereof. with respect to the competency, it was your conclusion that he was not feigning or malingering in the, in those portions of the test. Is that correct?
So there were two that assess response style, and you are correct about the inventory of legal knowledge. So the inventory of legal knowledge specifically assesses feigned incompetence, and his score was not at all suggestive of feigned incompetence at all. In terms of other aspects of malingering or symptom over reporting, his response style, the PAI indicated that he did present himself in an especially negative manner, so much so that the symptom profile was invalid. But again, that did not come to bear nearly so much on competency as the ILK. So yes and no, but on the competency specific test, there was no indication of feigned incompetence.
The kind of the test or measure for malingering as in the competency context. So the inventory of legal knowledge is just like a quiz, is that right? Kind of a true or false, here's what you know or don't know about about stuff.
Right. And the reason that it measures feigned incompetence is because there are statistics that show if a person's responding randomly, this is the percentage of items that they get correct. So he was well above that threshold.
And they don't do that like memory test thing anymore?
Well,
Rate 15 or something like this?
you would if the person was claiming to be incompetent because they can't remember anything about the legal system. So he wasn't claiming that, so I didn't administer it. I just don't put people through that unless there's some indication that they are feigning that type of impairment, and he wasn't.
Is the malingering conclusion kind of baked into that clinical test, you know, such that it's like there's like the threshold of that 61 items?
So with the 61 items, there is a threshold, and I'll have to look and see what it is. I believe that it's 43. But I believe at 43 and below, that is what a person would score if they were responding randomly. And in other words, kind of trying to miss items. So I've had, not very often, but I've had several cases where a person, for example, has answered correctly to 11. If you're responding randomly, or if you're responding hit or miss to 61 items, statistically speaking, you'll score much higher than that. So the norms on the test tell us that is suggestive of a feigned response style, meaning that the person intentionally tried to demonstrate impaired knowledge of the legal system.
Okay, and then I guess just briefly contrasting that with the personality assessment inventory, is that more of a subjective determination on what was kind of grossly overly negative, or is that something that was a conclusion produced by the standardized test?
No, that's very standardized. And so there is a negative impression management scale, and above a certain score is suggestive of negative impression portrayal. And it's on a continuum. So at some point it becomes so negative that the test becomes invalid, but that is definitely not suggestive. That's definitely a standardized scale.
And are the results of these tests that you had administered, are these preserved in a file?
Yes, sir. Yes, sir.
Judge, that's all I have.
You don't have anything?
I have no further questions.
Do you have any other witnesses?
No, yeah.
You have any witnesses?
No, Judge.
If you want to make an argument, Mr. Hammond.
Your Honor, I think it is clear from the report that
Can the doctor be
the
excused?
doctor has
Can the
submitted.
doctor be excused?
Yeah,
Doctor, you can be excused. Thank you.
Thank you so much.
Let's stay.
I think it is clear from the report and the details contained in the report that there's really no question about his competency or his capacity. I thought the most striking thing in the report, as best I could determine, he really didn't deny any of these incidents occurred. His answers to the doctor was, I don't remember. And you're talking about,
Well, let's don't get into that.
I've been just rely on the testimony of the doctor and the report. It is conclusive.
Would you like to be heard?
Judge, just ask you to find that he's incompetent, stand trial and submit on it beyond that.
Do you have any rationale that you want me to consider when I make that decision?
Just the record as it is before you, Your Honor.
Thank you very much. You know, it appears to me that he's competent and has the capacity to have a criminal responsibility. So I'll enter an order on that so you can put it to the record. Okay, thank y'all very much.
Thank you, Judge.
Is there anything else to come before the court on this case or any other cases before 1 o'clock?
Russell County did come in, if you want to go.
Okay, let's go to Russell County.
That's all I have, Your Honor. May I be excused?
Have a
Thank you.
safe journey.